5 commissioners in Rivers State have resigned from Governor Siminalayi Fubara's government, citing the toxic work environment. However, their resignation continues to elicit mixed reactions, especially among the supporters of Governor Fubara and his successor and FCT Minister Nwala. Arise correspondent Andy Emmanuel has details.
Call it a gale of resignations and you will not be wrong. Within a space of less than 5 hours, all 5 commissioners in the Governor Sim Fubara's administration on Monday threw in the towel. First was the Education Commissioner, Professor Chinedu Mom, then his counterpart in housing, Dr. Gift Walu, who passed on the baton to that for environment, Austin Ben Shioma. Then the last 2, Dr. Jacobson Mbina, Commissioner for Transport, and that for Social Welfare and Rehabilitation, Inine Shiwenwu Aguma. Expectedly, their resignation is eliciting mixed reactions.
First, they were appointed by Governor Fubara, and they accepted to work with Governor Fubara. Whatever they have informed them to resign is personal. I don't want to talk about another man's problem. They were appointed, they have served for like 8 months or thereabouts, and they decided to resign. I don't want to link it to any politics, because time for politics is gone. This time for governance. So whatever informed these commissioners today or yesterday to resign is mainly their own cup of tea. It's not politics. That's the way I want to take it. Fubara is the governor of Rivers State. He hired them. If they decide to resign, it's left for them.
It's a welcome development to APC as a party. I know their resignation is for our own development. So since I don't have anything to say about PGP in the area of Sim Fubara, making peace within his cabinet.
But what are the likely implications of these resignations, and what should Governor Fubara do to mitigate them?
Before somebody resigns in any office, you know that the office is not comfortable for him again. So it's best to me to choose this one that can work with him. You cannot work with your enemy. So you make just the one that we can hear from you and obey your condition. So you cannot work somebody that you tell, go and buy this thing, you tell that I will not go. So 2 masters cannot sit in one seat.
When a man wants to do more than God's will, the will of God will run into him. My advice to governor is that he should restructure his cabinet, because you can't have people that is not your loyalists. You can't have people that will not work with you. And I know what it is. Rivers State Fund is not meant for just one person. So if the commissioner feels they are not comfortable because the due process is not yet to be due, there's no problem, they can resign.
All 5 commissioners are pro-Wike, whom he reportedly nominated for the Governor Fubara's cabinet some months ago, before the lingering political crisis that is beginning to fester. In Port Harcourt, it's Andy Emmanuel, Arise News.
A very interesting quote there about the will of God and the will of God running into you, but it's fine. But meanwhile, it will be recalled that Justice Charles Nwala of Rivers State High Court in Port Harcourt has restrained 25 lawmakers in Rivers State loyal to the Minister of the Federal Capital Territory, Chief Nyesom Wike, from parading themselves as members of the Rivers State House of Assembly. So joining us now on the show as we continue yet another series of the Rivers State political crisis, we look at legal angles surrounding the crisis, is Emmanuel Aneme, a lawyer representing the defected 27 lawmakers of Rivers State Assembly. He's also joined by Chetam, Thierry, and Nwala, a lawyer and indigene of Rivers State. I mean, let's go straight to it. I'd like to come to you first, Mr. Aneme, the lawyer representing 27 lawmakers. What's their case, and what case are they putting? And tell me all your legal representations as you have now as regards the plight. And Chetam, I would like you to also talk me through why this debacle is continuing. What will you have as a legal response, to these 27 lawmakers? I'll come to you first, sir, Mr. Aneme, Emmanuel.
Good morning, Rufai. Good morning, Ayo, and good morning, Nigerians.
Morning.
It's good to be here. Thanks for having me. Now, going straight to your question, the legal issues arising from the legal logjam in Rivers State. You can recall that Honorable Justice J.K. Omotosho of the Federal High Court sitting in Abuja here gave a considered judgment to the fact that, number one, the Honorable Martins Amehule's led State House of Assembly is the one recognized by law and the one has been certified by court. Now, order 4 given by J.K. Omotosho is to the fact that the 11th defendant in that suit, that is suit number FHC/ABJ/1613/2023 between River State House of Assembly and Right Honorable Amehule as the second plaintiff and National Assembly and others. In that judgment, J.K. Omotosho was very pointer to the fact that the 11th defendant, that is the governor of River State, is stopped for making a request, presentation, or nomination to any other State House of Assembly other than the one led by Honorable Martins Amehule. That judgment is subsisting. That judgment has not been set aside. Now, again, in another suit pending before FCTA, Federal High Court in Abuja here, in suit number FHC/ABJ/CS/1681/2024. It is pending before Honorable Justice Okoro. It is between River State House of Assembly and INEC. What is the less contested is there? The issue of defection from PDP to APC. The court gave an injunction restraining the INEC and the defendants from declaring the seats vacant and from proceeding to conduct election to fill those vacants. Now, number one, the judgment given by Honorable Justice J.K. Omotosho is still subsisting, has not been set aside on appeal. Now, the order given by the judge, Honorable Judge, in the second suit, is still pending. It has not been set aside. Now, if you fast forward it to a recent order given by Honorable Nwala of River State High Court, you are referring Nigerians to Section 272, Subsection 3 of 1999 Constitution as amended. It robs State High Court jurisdiction to entertain any matter with respect to whether the office, whether the tenure of a State House of Assembly or the governor has ceased to exist or become vacant. In that section, State High Court has no jurisdiction. And if you don't have a jurisdiction to entertain a matter, you also lack jurisdiction to make an order. So this ex parte order given by C.N. Nwala is given without jurisdiction. And for me, it is forum shopping, it is abuse of court process, and it amounts to self-help. And we cannot allow it in our democracy to function. We are operating a constitutional democracy where rule of law should hold sway. Now, the other angle to it is that on inauguration, the River State governor, who appeared before Justice J.K. Omotosho, and for reasons best known to him, withdrew all his processes. But he was a party in that suit, presented against Order 4, given by Justice J.K. Omotosho, Danogogo Ibiroma, a senior advocate of Nigeria, to be screened as a commissioner in River State government. That is against the spirit of order. That order.
Okay, can you hear me? Can you hear me, sir? It's not because of reasons best known to him. That's why I withdrew the suit. We knew he withdrew the suit because of the peace agreement that was signed hitherto. And the peace agreement that was signed, with the Tinubu peace agreement also stated that everybody should withdraw their suit from court, So if you withdraw the suit and your team didn't withdraw their suit, then there's a question, who violated the peace agreement? I'll come to you, Chetam, Thierry, and Nwala. Can you respond to some of these legalese he's talked about?
No.
Hang on a minute. You had your time to speak, sir. You had your time to speak. Let Chetam, Thierry, and Nwala speak, please.
It's okay.
Okay, good morning, Mr. Rafai, and thank you for having me once again. I want to start by saying that for me as a legal practitioner and one who actually swore an oath to protect the laws and constitution of this particular country, I must say it's really sad with what is happening in Rivers State, especially with respect to how the laws of our land are currently being flaunted, and of course the role of the judiciary in this entire crisis. I must say it's really sad for both the judiciary and for Nigeria as a nation, because it's plunging us into serious constitutional crisis. In one of my Facebook posts, I said we are now in a legal confusion, because you have orders flying left, right, and center, and counter orders from one end to the other end, which is really unfortunate. But in looking at the issues before us, my learned friend that talked about the Justice Omotoso's judgment. Let me also state clearly that no matter how a judgment is gotten or an order of court is gotten, it is an order of court, and it must be obeyed in the circumstance in which it was given. And it is for the higher court, in the Court of Appeal in this particular situation now, to determine to say the said judgment or the said order was wrong, and set aside or vacate such an order. But once an order is given by a court, that order, no matter how wrongly procured, must be obeyed. Now, when you look at the Omotoso judgment, some of us who are actually public affairs analysts have looked at it and also criticized some of the issues held in that judgment, and we have said no, this is unknown to law. And on the strength of that, currently the matter is on appeal. To the best of my knowledge, the matter is on appeal, and of course we are expecting that the Court of Appeal will look at the matters and actually take proper actions in line with our laws. But now, coming down to the issue of the last interim order given by Justice Wale in Port Harcourt, and when we talk about the issue of jurisdiction, the question we should ask ourselves: what are the main prayers before the court? Did Victor Okojombo go to court to ask the court to vacate, to declare the seats of these 27 lawmakers vacant? No, that was not exactly what the court did. Victor Okojombo simply went to court to say that my right is, as Speaker of Rivers State House of Assembly, whether how wrongly or rightly done, that my right as the Speaker of Rivers State House of Assembly has been infringed upon, and I'm asking the court that, or is likely to be infringed upon by these 27 lawmakers, that court please help me in this circumstance, and ask these people not to parade themselves as Rivers State House of Assembly, because in parading themselves, they'll be infringing on my rights. That was exactly what the Victor Okojombo led assembly went to court to do. And the court, in their own wisdom, felt that it is necessary to actually give an interim restraining order. Don't forget, an interim restraining order is meant to last for about 7 days, or if the court decides to make it substantive, then the court can go ahead to do that in the subsequent date given in the circumstance. But this is exactly the position of things as it is. But now, that is a court order, and it has to be obeyed. And that is my own position, that irrespective of who gave the court order, when Justice Omotosho's judgment came, some of us argued and said, it is a judgment of court, no matter how wrongly we felt that the judgment was reached. And the judgment must be obeyed. And to the best of my knowledge, that judgment was also obeyed. Now there is an order of court that is saying that the 27 lawmakers should restrain themselves from parading themselves as lawmakers. That order has to be obeyed until it has been vacated. Whether the court has jurisdiction or not, which is not, of course, in question in this particular situation, whether the court has jurisdiction or not to still carry out that particular action, it's for the Court of Appeal to actually determine. Or it's for the council on the other hand to actually raise those issues. But the order as it has been given today must be obeyed, because it's an order of court. If orders of court are no longer be obeyed in our climb, then we'll be actually heading into anarchy. And that is why some of us have argued and said, the court has given this order in this respect, that all parties must maintain that particular order as given by court.
Okay, all right, Mr. Aneme, thank you, and Mr. Nwala, when you respond to this question, if you want to, I know you wanted to respond to something earlier, you can then add that to this. But I want to talk about the Rivers State House of Assembly. You've explained with regards to court orders, irrespective of how they are obtained or how the journey towards that must be obeyed. We hear you. Now, in terms of the legality and quorum of the current House of Assembly, the pro-Fubara one, which is said to be the legitimate one if the 27 lawmakers no longer hold their seats, having defected to the APC. What's the legal perspective on this? Can they, as they've done in the past few days, one, elected a new Speaker of the House, two, are able to screen nominees? The Attorney General of the Federation, the Attorney General of the state was also screened, endorsed, and has been sworn in as substantive. What is the legal implication? Can they do that, despite the fact that they're only 3 in number? I'll start with you, Mr. Aneme, and then Mr. Nwala, you can weigh in on this too.
Yeah, thank you once again for giving me the opportunity to respond. Now, let me go back to what I was saying before I was cut short. When the Excellency Governor Fubara withdrew his processes at the Federal High Court, he did not clearly state the reasons for such withdrawal. He didn't say he did it because of the so-called agreement made in Aso Rock. That was not the reason. So this one is gesture, and I'm not here to gesture. I speak true to fact. He withdrew that processes based on reasons known to him, and the court took cognizance of the fact that the 11th defendant, who is the governor of Rivers State, did withdraw his processes. The court didn't say anything further than that. That judgment is standing. Now, if you go to the judgment of Omotosho that stopped the governor from making presentation requests before any House of Assembly, that order was not vacated even by the ex parte order given in Port Harcourt. He was not vacated. Now, talking about what my colleague said, that the Speaker, Jumbo, went to court to say, my right is being likely to be violated. Now, if you look at what he was saying, the ex parte order came to say these 25 or 27 lawmakers should stop parading themselves. In effect, that ex parte order has determined their tenure against the spirit and intendment of Section 272, Sub 3 of 1999 Constitution as amended. And jurisdiction is everything in law. If you don't have jurisdiction, you don't have jurisdiction to make an order. If you read the case of McFord against USC, Madukor against Nkemdulum, you cannot put something on nothing and expect it to stand. That ex parte order was built on quicksand and it will collapse. Now, if you look at the way and manner ex parte orders are being given, I filed an action before the Federal High Court. I filed affidavit of urgency. I filed motion ex parte. I filed motion on notice. I filed interim injunction. At the end of the day, the court looked at the processes, and instead of granting the ex parte order, the court granted accelerated hearing. So what is emergent about the case pending before the Port Harcourt High Court judge? That he did not, against all caution, he gave an order that is overridden against the defendant without allowing those defendants to have a say. Now, ex parte order lasts for some time, but in this case, it's been implemented as final judgment of the court. And that ex parte order, like I said earlier, does not in any way vacate the order given by Omotosho that is still subsisting. Now, let me go to what you said about quorum. Now, if you read Section 96 of Section 1 of 1999 Constitution as amended, he said that the quorum of State House of Assembly shall be 1/3 of all the members, everybody. Now, Subsection 2 says, if at any point in time the Assembly did not form a quorum, it will adjourn. Now, in this case, it was not the intent of the drafters of 1999 Constitution as amended that only 3 will be sitting out of 32 lawmakers. When you have 32 lawmakers, then 27 on the other side, then 4 on the other side, then the other one resigned. That's not the intent. What you have is the Speaker, the Deputy Speaker, where are others? If you don't have a quorum to sit, you also lack the capacity to carry out any legislative business. And if you carry out any legislative business, irrespective of lack of quorum, that business is null and void. So in all these cases, we are lawyers, and we should defend the Constitution irrespective of whose ox is God. My defense of Constitution does not stem from the fact that I like Wike or I like the 25. I am defending 1999 Constitution, which I uphold in the day I was sworn in as a lawyer to defend. We cannot sit down here as lawyers and watch our Constitution being desecrated, being denigrated because of politics. Yes, you can play your politics the way you play your politics, but 1999 Constitution, the provisions to it must be implemented. And in this case, the 3 lawmakers did not form any quorum to carry out any valid legislative business of the House. And the screening of the Nene Senior Advocate of Nigeria, who is now the Attorney General of Rivers State, is invalid. It's illegal. It's unconstitutional. And will not stand because it was done against a substituting order that has not been appealed. And let me say it for the updated time. If, like he said, my colleague said, that they did not agree with the judgment of Justice Omotosho. If you don't agree with the judgment, there is a laid-down procedure. You file a notice of appeal, and in that notice of appeal, you tell the court of appeal the part of the judgment you disagree with, and then you battle it home. That did not happen. Here. Not to go to Port Harcourt.
Your point has been established.
Not to go to Port Harcourt, and I'm quoting him now. He should, no matter how judgment is procured. I'm a lawyer, we don't procure judgment.
All right, thank you.
Thank you, Mr. Aneme.
Let's go on to Mr. Nwala. Thank you. Your point has been well established. Mr. Nwala, your take on this, please.
Let me draw to your attention the fact that Section 102 of the Constitution clearly states that irrespective of, now I'm talking about the issue of quorum and the number of persons who actually make up an assembly, that the number of persons who actually make up an assembly the actions are not invalidated because the said number is not up to the actual number that was clearly stated. Now, let me give you an instance. If you look at the case of Dapialong versus Darie, where it was clearly what happened in Plateau State was clear. We had about 7 members who actually were members of the Plateau State House of Assembly, and the 10 members carried on business as members of the House of Assembly, irrespective of their number, which is not actually the total number of persons. They carried on business, and the court actually did not void any of those actions they must have actually taken. Now, the court was only concerned on the issue of impeachment, but as for carrying out other activities as members of the House of Assembly, the court actually gave a nod to it, which is now a precedent in our own corpus juris as of today. Now, when you look at that particular case and refer it back to what has happened in Rivers State, the Iboroman's nomination and subsequent House of Assembly actions and all that, it does not in any way invalidate it. So they are hiding under Section 102 of the Constitution to take up this particular action. And you see, the truth of the matter is that we can't sit in this studio and determine which court has jurisdiction and which court does not have jurisdiction. If you feel that the court in Port Harcourt does not have jurisdiction to take up an action, it is left for you to go and challenge the jurisdiction of the court. It is not for you to sit in the studio and to say, oh, Port Harcourt High Court does not have jurisdiction or it has jurisdiction. It is for the court to determine, because we are not the court to determine in that particular circumstance. The order has been given in this circumstance, which is an interim order. And I don't know why you should be worried when an interim order, have a very short lifespan. And you can also challenge these things in court. I don't know why he is actually worried about it. Then, now when you also come back and look at the actions taken by the House of Assembly, how does the action taken by the House of Assembly invalidates the laws or the Constitution of the Federal Republic of Nigeria? Now, he is talking about a situation where we have the Justice Omotosho's judgment, which actually touched on other parts of the judgment, which the interim order does not, according to him, invalidate. Now, let me say this: the Rivers State High Court was not standing on as an appellate court to the Omotosho's judgment. It had its own issues raised before it independently, and those issues were reached. The interim order were actually given in light of that particular situation, but. Let us look at this. The court said 27 lawmakers should stop parading themselves as lawmakers. So it simply means that if the Omotosho's judgment said that that the governor in question should not present any other thing except to the Matamirule-led assembly, and there is a conflicting judgment to this particular order to particular effect, saying that this person should not parade themselves, then it is those who actually stand as assembly members that he would actually go to, which is exactly what the governor has done. And in my own opinion, I don't see anything wrong with what the governor has done. But if my learned friend here thinks that what the governor has done is wrong, it is within his right to also approach the courts. And let me also state this: to the best of my knowledge, the Justice Omotosho's judgment has been appealed against.
Okay.
It has been appealed against. So it is wrong to come and say that the judgment has not been appealed against.
Okay.
It has been appealed against.
Okay,
We are only waiting for this Court of Appeal to also make a pronouncement on this particular issue.
Okay.
The position I have held and I will continue to hold is that judgments and orders of court must be obeyed and should be obeyed to avoid anarchy in our society.
Chetam, you made your point. Mr. Emmanuel Aneme, you can go and check newspaper cuttings from the 20th to about the 25th of December last year. You will see it copiously clear that in response to the quid pro quo deal signed by President Bola Tinubu, the River State lawmakers that wanted to impeach the governor said they were going to remove their impeachment notice, and the governor in turn was going to take the case out of court. So even if it was not put in the court document, that was the exact reason for why it happened. And it was around that period that Commissioner Johnson came out many times in the state to be able to restate the fact that Mr. Fubara was going to follow the peace deal. At first, there were contentions about his signature being on that deal in the first place, but he came out. And also, I would like to stretch your memory further. At a particular speech he gave at a medical university owned by Mr. Odili, he also said that no price is too big to pay for peace, which also talked about those terms, those legal terms. So that's just for proper context. You can go and check all of those newspaper cuttings. I want to also ask you, how does all of this, wait a minute, let me finish, you can answer your question. How does all of this juxtaposes with the Abegude case? All right, Chetam, I'll come to you to also analyze this and juxtapose it with the Abegude case as regards, defection, and also you, Mr. Emmanuel Aneme, juxtapose it with the Abegude case.
Okay, now, first of all, about the newspaper column you quoted, I'm quoting the judgment of the court, a substituting court judgment. That judgment did not make reference to that newspaper column. And I'm not here to discuss what newspaper publicize in their column. That is for them to publicize. That's the understanding of what transpired in the court. But I'm quoting a substituting order of the court. What it said. I'm not quoting newspaper column. I've not read that. Now, coming to other issues you raised about what the governor spoke about, no price is too big for peace to reign in River State. Part of that agreement that you are quoting said that the governor should represent 2024 River State appropriation bill before the Amehude-led House of Assembly. Did he do it? He did not. And if you read that Justice J.K. Omotosho's judgment, he clearly invalidated River State 2024 appropriation law. He declared it invalid and cited the case of Ogbobe against Oliji that was decided in 2011, Law Pavilion Law Report 4530 by Court of Appeal decision. This was the decision that the court relied upon to invalidate that bill passed by 4 members of River State House of Assembly. And as we speak today, that order has not been validated. That order is subsisting. Now, my colleague here is saying that the judgment given by J.K. Omotosho has been appealed against. If that judgment has been appealed against, why the hurry? Why shouldn't they have waited for appeal to take decision in one way or the other? What is emergent about River State situation that will warrant the issuing of ex parte order in a situation like this? I am saying that I remain, the 25 lawmakers are saying they are still members of River State Assembly. By ex parte order, you breach their right without hearing from them. What the judge would have done, even if he has jurisdiction, assuming without considering, but he doesn't have jurisdiction by virtue of section 271. He is talking about jurisdiction that it shouldn't be, it's not the case here. Let him quote the section of the Constitution that empower the State High Court to entertain matter that deals with whether a tenure of a State House Assembly has elapsed or not. If you stop parading yourself as a State House Assembly member, that ex parte order is overreaching and it has invalidated the whole process.
Okay, so I asked a question to juxtapose this with the Abegude case. What's your take on that? Juxtapose this with the Supreme Court judgment in the Abegude
case said.
Go ahead.
Yes, the Abegude case, if you read that section 109 subsection 1G, it's not self-executing. It's not automatic. There is a serving senator of the Federal Republic of Nigeria today that decamped from Party A to Party B. I don't need to mention his name. If he's self-executing, he would have lost his seat. He's not self-executing. Now, because there is a proviso that says if there is a faction, if there is a division, if there is merger. Now, these are questions of facts. If you approach the court to say this is why I decamp from PDP to APC. The court will look at the situation. The court will hear all the other parties, unlike what they did in Port Harcourt, to hear one party and give an interim and give an ex parte order that is overreaching. If the court at the end of the day decides that 25 lawmakers have lost their seat and they could not justify it by that proviso in section 109 subsection 1G, they will lose their seat automatic. So, but it is not for anybody to say that having decamped, it's not for anybody to say.
Can I ask you a quick question? If you say it's not because of the Tinubu deal that Fubara pulled his case out of court, why did he not pull the case out of court first before the Tinubu deal?
No, I did not say. I said reasons best known to him. I quoted judgment. I don't say because
I'm just asking you a question. If you say hang on a minute. Let's go off this quoted judgment, because it's not everything that's written in the judgment expressly. You know, that's why you have out-of-court settlement that are not written in judgments. All right.
You are interpreting the court judgment. Hang on a minute. The court judgment is written in black and white.
Hang on a minute, sir. If you say it's not because of the Tinubu deal, why didn't Fubara take his case out before the Tinubu deal?
No, you see, the question you're asking me is left for Fubara to, His Excellency Governor Fubara to answer. I am saying that the judgment I read did not make reference to the fact that he pulled out his processes because of Tinubu deal. And I did not, you are putting words in my mouth, I did not say that the governor did not withdraw it because of Tinubu deal. I said the judgment of J.K. Omotosho that I read, and I'm quoting copiously, did not make reference to the reasons why the governor pulled out his processes.
So, but you admit now that
should be noted.
So, can I just ask you a question quickly? You admit now that the Tinubu might have influenced him pulling the case out of court in the first place.
No, that is for governor to decide. I don't know what's operating in his mind. Like he said in law, even devil is there, not the mind of man. I don't know what was operating in the mind of governor.
Okay, I'll move off you now. Chetam, Harry, Nwala, please go ahead. Respond to most of this, and also cite the Abegunde case.
Let me say this. You know, the truth of the matter is, one of the things I have learned to do as a person is not to come to public to, because of my affiliation, decide to take certain sides and all that when we want to look at issues for proper development of our country and our state. Let me state clearly that it would be wrong for my colleague here to come here and said that he's not aware that the matter the governor withdrew from the court was not as a result of the presidential peace pact. We all know that. Even the least man in the village understands that that is the reason. And they also failed to withdraw the matter before Justice Omotosho. And Justice Omotosho went ahead after that peace pact had been reached, after the governor has carried out his own part to withdraw the matter. They failed to withdraw theirs, and Justice Omotosho went ahead to give judgment in light of that. And the governor, in his own wisdom, still said, okay, even if you have done this, I am not going to appeal this matter. And the governor delayed in appealing the matter. And that actually stayed up till this particular time, until lately when these issues arose again, and they decided to appeal the matter in court. Now, that's to tell you how much he decided to keep to the peace pact. Then, if my friend is saying that just the section 109 of the Constitution is not automatic, see, let's be clear about this. When a section of the Constitution has been decided by the courts, it does not need further interpretation of the court again on the matter for it to take simple effect. The issue of defection has been decided on several occasions. The Abegunde's case, which is the locus class in this particular situation, the Apialong versus Darie matter, which is also a part of this particular matter that has been raised, has decided and said that the moment you defect, you will lose your seat. There is no gainsaying about it. There's no gainsaying. You don't need the court now to determine whether you should lose your seat or not. That is an automatic loss of seat. If he is making reference to a senator who has defected and people have decided not to challenge it, that becomes their own cup of tea, and that becomes their particular issue. But on the merits here, these 27 lawmakers naturally should lose their seats. Then now, when it comes to the issue of the ex parte order, let's be quite clear about it. The ex parte order did not at any point in time declare the seats of these assembly members vacant. It only said, stop parading yourself as members of the Rivers State House of Assembly, because you're parading yourself as members of the Rivers State House of Assembly will infringe on the rights of Victor Okojombo and those who actually went to court with him. What is that right? Because the matter before the Rivers House Assembly has to do with the rights of Victor Okojombo as Speaker of the Rivers House Assembly. And if these men continue to parade themselves as members of the House of Assembly, they are naturally infringing on the rights of Victor Okojombo. It's as simple as that. So the court at any point did not also say that you should vacate your seat, did not reach a final judgment of this. This is an interim order. Why are they now declaring in the studio saying that the court does not have jurisdiction? Is it within our powers to decide that? It is for the courts to decide. It is not within our powers to so do that. So I just want to advise that then you return back to the court. The order has been given. The order should be obeyed. You return back to the court to vacate it. Because if everybody decides to act the way they want to act, then we'll find ourselves in anarchy.
Mr. Nwala. All right. I'd just like to come in here because you talk about it being, because it's been decided at Supreme Court, so it's automatic that they lose their seats. However, the relevant part of the Constitution is Section 68, 1 and G, and there is a provision, and I'll read that if you permit me, but provided that his membership of the latter political party is not as a result of a division in the political party of which he was previously a member, or of a merger of two or more political parties or factions, by one of which he was previously sponsored. In the event that the 27 lawmakers are able to prove and that perhaps there was some division that made it necessary for them to defect, they would have a case. So it's not exactly that, as you said, that it is a whole, whereby once it has been done because it's been decided, then they automatically lose their seats. They can still defend or prove in court that there was, I'm not saying that's the case, but there's a provision for that, is what I'm saying. So it's not, it cannot be said to be automatic. I don't know.
Our laws on these issues are explicit. Even the section you had read, our laws on these issues are quite explicit. The statement I made is clear. If a matter is decided in court, naturally, and there is a precedent to that particular effect, it doesn't stop you from actually exercising your rights to challenge that particular situation. That is one point I want to actually clear on that. However, these sections of the constitutions are automatic. You don't need the court to determine whether you should lose your seat or not. You don't need the court to determine that, if you should lose your seat or not. If that is the case, everybody will be in court trying to determine this particular situation. So, in this circumstance, you do not need the court to determine it. Now, where you actually claim that there is conflict within the party, the only thing you need is the speaker should declare the seats vacant, which, of course, during the time of Edison here, he actually declared the seats of these 27 lawmakers vacant. And in declaring that these seats of the 27 lawmakers vacant, Edison here, in line with the agreement of the Peace Pact, withdrew his matter in court, resigned as Speaker of the Rivers State House of Assembly. That also gave rise. Now, within that period, the Justice Omotoshaw's judgment came on, which actually returned Matamewule as Speaker of the Rivers State House of Assembly. Now, in light of that particular judgment, the governor obeyed it and followed it through. Now, there came again a substantive interim order of courts, which actually now said that these 37 lawmakers should stop parading themselves as lawmakers in this circumstance. As lawmakers in this circumstance. Now giving rise to that particular section, and giving rise to also the act which was carried out by Edison here. And in that case, it becomes the order of court and should be obeyed. It should be obeyed. You don't need to go back to court to ask the court to determine. If you feel if the 27 lawmakers feel at any point that their right is being infringed upon, at any point, they can actually approach the court to actually determine that. But saying that this particular provision is not expressed and cannot come into effect until a court pronounces on it, that's the wrong interpretation of our laws.
Okay, so I'd like to also get your take, Mr. Emmanuel Aneme, as a reaction to what he said as regards this incident of, this Abegunde case and the constitutional proviso there. I want you to react to that. Mr. Aneme.
Now, it's very, very clear, like I said before, that proviso, that section of the Constitution is not self-executing. If it was self-executing, a senator that decamped, you have your Gogo there. Gogo, the senator that decamped from Party A to Party B. Within this time, within the time under review, he did not lose his seat. And let me tell Nigerians, there is nothing like judgment in rem. What we have is judgment in personnel. Because no two facts are the same. That is why you need to approach the court for determination whether these 25 lawmakers that decamp from PDP to APC met the requirement of the Constitution. If they met the requirement of the Constitution, they will lose their seat. But if they did not, if they did not meet the requirement of the Constitution, they will return. So what the lawyers here said, that you don't need a quorum. That if you don't have a quorum, the House can sit and validly pass legislative business. That is wrong. He cited the case in Plateau State. That is also wrong. 6 lawmakers went to impeach His Excellency Peter Obi in Grand Hotel Asaba. The court invalidated it. They don't have quorum. They don't even have the jurisdiction to sit. That is what we are talking here. Section 96, subsection 1, you can read it. If you say, if at the any point in time, the House did not have a quorum, they will adjourn. Why didn't they adjourn? Now, talking about the order he's talking about, there's what we call court of coordinate jurisdiction. There is also what we call court of concurrent jurisdiction. If they had gotten that order from Federal High Court sitting in Port Harcourt, it would have been a different thing. As at that time, we'll be discussing the fact that the court that has jurisdiction, the 2 courts that have jurisdiction to entertain this matter, have given orders. So which one do we obey? But what we have is a court that has no jurisdiction in toto to swing into the matter and gave ex parte order where it is needless, where it's uncalled for, and where it's unconstitutional. So I don't know why we are justifying this thing. And if we want to sit here and say, if that session is self-executing, what we are calling for is self-help. Because somebody can wake up tomorrow and say, I don't like your seat, I don't like your face, you have lost your seat. So what do? Let us be mindful of what we are doing. And he's talking about the governor obeying the Abuja Accord. Hang on a minute, Rufai. He said the governor about obeying the Abuja Accord. Ask him. Why did the governor not represent 2024 River State Appropriation Bill that has been invalidated by judgment of J.K. Omotosho and also invalidated by that Abuja Accord? Okay. Ask him the question. Okay. Mr. Chetam, as we thank you, there's a question Mr. Aneme has posed. Answer that question. Why didn't he add the Abuja Accord, to be part, this Abuja Accord that says also you should represent that budget? Why didn't he put that in the deal so that there's a complete deal? That's number one. And number two, how does all of this also feed into a scenario that happened in Edo State where we had impasse with lawmakers and those ones were in limbo for a while? As we wrap up, Chetam. 1 minute. Okay. First of all, let me just state clearly that because an illegality goes on unchallenged does not in any way makes the thing to be legal. Because when you keep making reference to what is happening at the National Assembly over the defection of a senator, so for that reason that an illegal action takes place, so such illegality should continue in the River State, then I find that troublesome, worrying, sorry. Now, in this particular scenario, what has happened at the National Assembly is illegal because nobody has challenged it, does not in any way make it to be legal. So what is happening in River State is illegal. And that is why we are saying that these people have lost their seat automatically. They don't need the court pronunciation on the matter. So if they simply want the court to pronounce on it, they should as well go ahead to ask the court to protect their rights, which is what they did. That was why Martin Amehule ran to court to make these particular claims. Now, when you still talk about, I have stated this clearly, that the issue of jurisdiction is clear. That the matter before the River State High Court is not in declaration of the seats of the 27 lawmakers vacant. And that was why they were careful in stating that these people should stop parading themselves as members because you are infringing on the rights of Victor Okojombo as Speaker of the River State House of Assembly. Now, as the governor not representing the budget before the River State House of Assembly, are you with me, please? Yeah, quickly, as we wrap up. Quickly, 2 seconds or 3, if less. As to the issue of the governor representing the budget, let me ask you in the clear terms. We agreed we should all withdraw our matters. You didn't withdraw your matter. We agreed certain steps should be taken. I have taken almost about 6 of those steps. You have refused to take any particular step in line with the political solution that was provided.
Okay.
And now you're only bothered about just one I did not do.
Okay,
you're only bothered about it.
Let's hang it there.
And you're saying that when you have clearly violated the peace pact, that was reached.
Let's
that was exactly what happened in Rivers State.
Let's hang it there. Anyway, in all fairness, also the lawmakers didn't withdraw the case from our court, even when the governor withdrew his. We'll take a short break now. Thank you both for being here.